sabotaging or what they call ambushing. They're going to have any more charges, any more things, and they hit that there. And to this day, it wouldn't address it. And to this day, Mexican court was brought up again by Mr. Patrick Adams, a new attorney on the case, and still they're avoiding it. They're avoiding it.
Well, basically, in the federal system, court system, Dr. York was indicted under the Mann Act, indicted under 4 counts. Right? We had the Mann Act, Title 18, 2423A, which was transporting minors across interstate for the purpose of having illegal sex or unlawful sex. And you had Title 18, 2423B, which constitutes traveling. All right. Now, the difference between transport and traveling is that on one hand, they're saying that through money, intent, you cause person or persons to go through the transportation system, whether it could be Greyhound or anything that you did not personally engage in terms of steering them to that particular destination for the person having sex, and traveling meaning that you facilitated it. Okay, either they drove in your car or you accompanied them, all right, across interstate for the purpose of having unlawful sex. Those were the main 2 charges. They also cited the statute of limitations, their right to prosecute this case under Title 18, 3282. Okay, 3283. Okay, and what they had done through the federal law, they superseded a general statute of limitation, which was 5 years. Okay, by amending another statute of limitation to that one. Okay, so the general offenses, all right, as long as it wasn't capital, all right, was 5 years. Okay, then all right, they had put this other statute, which I felt at the time was in opposition to a statute of limitation that was already on the books. All right, now you got 2 statute of limitations. One that was the nature of it was dealing with white slavery, okay, and also dealing with giving the prosecutor, I think, 25 years or so to prosecute for unlawful sexual activity. Okay, now keep in mind now, at no time did the federal government ever use the word molestation. All right. They use sexual activity. And if you go back and look at the Mann Act, which was created to go after Jack Johnson in around 1910, all right, the act was specifically designed for prostitution, okay, white slavery, and transporting of that across the commercial avenues of federal highways of the federal government.
The United States White Slave Traffic Act of 1910 prohibited so-called white slavery. It also banned the interstate transport of females for immoral purposes. Its primary stated intent was to address prostitution, immorality, and human trafficking. The act is better known as the Mann Act, after James Robert Mann, an American lawmaker. The first person prosecuted under the act was black heavyweight boxing champion Jack Johnson.
Molestation in its nature is a state law. Okay, it's a state law. It stands the reason why the federal government would not have a molestation law, because the states have already one in effect. And for the federal government to have a molestation law, all right, in parallel with the state, okay, it would only be a violation to the 10th Amendment, which said that powers not delegated to Congress are reserved for the states. The states already had a child molestation law. Okay? Now, interjected in that was the fact that the state, using the Mann Act, never prosecuted Dr. York as being a pimp. They prosecuted Dr. York as being a child a molestator. Now, that was a state case that they presented. The problem with that was that the state had never consented, okay, its power or conferred its power to the state, definitely not in writing, okay, because you had this dual sovereignty doctrine that allowed both federal and state to simultaneously attack you with the same offense, okay? Now, what that meant was that the federal government had to have laws in place that was independent of the state. Because remember, you got two sovereigns coming after you. All right? Now, but that didn't happen in Dr. York's case. The federal government, if you go through the transcript, the federal government used the term molestation. The problem was that there was no molestation, there are no molestation laws in the federal United States Code. All right? Now, we can assume what we want to assume. But the actuality is that the law is highly defined and highly specific. All right? The state, if you go look at the state,